turn next to Mr. Palmer, please.
Thank you, my lord. My lords, this is rather an unusual form of appeal because we find in the red corner Lords Sumption and Hughes from Brownlie 1, Lord Justice Arnold in the Court of Appeal in this case, and to some extent the Court of Appeal in Brownlie 1, and they support the appellant's plea that a personal injury and fatal accident act claim caused by a tort committed in Egypt does not fall within CPR 6 PD 3.19a. In the green corner, we find Lady Hale, Lord Wilson, and Lord Clark, with Lord Justice McComb from the Court of Appeal in this case. Lord Justice Underhill, I think it's fair to say, didn't really enter the ring, and so I will describe the teams as I have. My lord, I say that because your lordship's task is not really to determine whether the Court of Appeal is wrong or right, but to determine what the law is and to choose between the views expressed by the participants in the debate whom I've described. It's not our intention, therefore, to take you in any sort of detail to their judgments or speeches, but rather to rehearse the arguments which we say should convince you and should have convinced the green corner that the judgment of Lord Sumptions and Hughes represent the law of England as contained in the above captioned provision. My lords, of course, there is no inherent or common law jurisdiction or power of the English courts to entertain and rule on a dispute against a foreign defendant, save where that defendant has been served within the jurisdiction. Everything else regarding foreign claims or claims with a foreign element is statutory. The statutory legal framework creates gateways which do no more than give the power to the court to accept jurisdiction over a foreign defendant. And that is by the process of permitting service out of the jurisdiction. The meaning of a gateway, i.e. the precise scope of it, is a question of law and a matter of statutory interpretation. The relevant statutory words which create the power in this case are: a claim is made in tort, where A, damage was or will be sustained within the jurisdiction, or B, damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction. Some of the participants in the debate have described or construed those words by reference solely to their ordinary and natural meaning. As an example, Lady Hale, paragraph 52 on page EF 1795 at letter F. I'm not intending to take your lordships to that. And that assisted them in arriving at a construction which is different from the one we propose. We submit that simply referring to ordinary and natural meaning is not the correct approach. The correct approach is to start by considering the context and purpose of the legislation in question. Lord Justice Arnold says this at paragraph 70 of his dissenting judgment at EF 184. But if I could take you to the case of Bloomsbury, which is at EF 1748, and start at 1748 with the head note: the Sea Fish Industry Authority was required to exercise its powers to promote the efficiency of the sea fish industry, to finance its activities, was empowered by Section 3(4) of the 1981 Act to impose a levy on persons engaged in the sea fish industry defined to include importers in respect of sea fish and sea fish products, quote, landed in the United Kingdom, unquote. At page 1755, I refer to the speech of Lord Mance at letter H, paragraph 9. The first issue is whether the statutory power enables a levy in respect of sea fish first brought to land by the catching or another vessel outside the United Kingdom and only later imported into the United Kingdom. And 3 lines later on, there is a choice between a wider and a narrower sense of the word landed in section 4.3. The former would cover any form of bringing into the United Kingdom, commonly by sea or air, wherever the sea fish or fish products may have been first landed. The latter would cover only their first landing after catch. Mr. Justice Hamblin acknowledged that the narrower meaning was, in many contexts, likely to have been intended, but considered that in the specific context of the 1981 Act, the wider meaning applied. Lord Justice Richards, giving the only full judgment in the Court of Appeal, started with the provisional view that the normal meaning did not cover the arrival of fish on a ferry or aircraft from another country, and it would be highly artificial to extend it to their importation by road or rail. He looked at the factors on which the judge had relied and found none of them sufficient to displace that view. In matters of statutory construction, the statutory purpose and the general scheme by which it is to be put into effect are of central importance. They represent the context in which individual words are to be understood. In this area, as in the area of contractual construction, the notion of words having a natural meaning is not always very helpful. See Chartered Reinsurance and Fagan. And certainly not as a starting point before identifying the legislative purpose and scheme in the case of a statute which has, like the 81 Act, been the subject of amendment. It's not likely to be concluded that Parliament, when making the amendment, misunderstood the general scheme of the original legislation with the effect of creating a palpable anomaly. That's all I want to refer you to in that case. There is also the case of the Crown against Quinta Valley, I think it is, at EF 2478. And in the head note in that case, letter E, the claimant on behalf of the Pro-Life Alliance, an organisation which opposed human cloning, claimed by way of judicial review a declaration that organisms created by cell nuclear replacement were not embryos within the definition of section 1.1 and not subject to regulation. And then under the holdings, held dismissing the appeal, that section 1.1 was to be given a purposive construction and to be interpreted in the context of the 90 Act as a whole and the circumstances leading to its enactment. That since the Act was passed to protect live human embryos created outside the human body in vitro in a context of rapid medical and scientific development, raising difficult and sensitive issues, since the Act prohibited specified practices but permitted certain others which were made subject to comprehensive and strict regimes of control, it was plain that no activity in the field was intended to remain outside the scope of the regulatory system. And then at 2486, at the top, paragraph 7, such is the skill of parliamentary draftsmen that most statutory enactments are expressed in language which is clear and unambiguous. But these are not the provisions which reach the courts, at any rate the appellate courts, where parties expend substantial resources arguing about the effects of a statutory provision. It's usually because the provision is capable of bearing 2 or more different meanings, or to be of doubtful application to the particular case. And then paragraph 8, the basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed, but that is not to say that attention should be confined and a literal interpretation given to the particular provisions which give rise to difficulty. Such an approach not only encourages immense prolixity in drafting, since the draftsman will feel obliged to provide expressly for every contingency, it may also lead to the frustration of the will of Parliament, because undue concentration on the minutiae of the enactment may lead to the court to neglect the purpose which Parliament intended to achieve when it enacted the statute. Every statute, other than a pure consolidating statute, is after all enacted to make some change or address some problem or remove some blemish or effect some improvement in the national life. The court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. That was all I wanted from that case. Another swift reference to Lord Justice Toulson at cited in our case. I haven't taken you to the, I can take you, sorry. 3614. Sorry. Paragraph 65, the relevant provision of the Act do not provide a definition of security and welfare or safety and welfare. The expressions are certainly apt to cover matters of the sort to which I referred, exposure to risks of death, injury, and other forms of harassment. My lords, this is in the context of a police duty to individuals to look after their safety and welfare. Exposure to risks of death, injury, and other forms of harassment, there are risks of a physical nature. The imposition of a duty of care for the safety and welfare of the CHIS, in that sense, would be consistent with the purpose of the relationship being one of confidentiality. It's, in my view, just reasonable that police should owe a duty of that kind. Claimant's argument, or C's argument, is that the police owed him a duty for his welfare of a much broader economic kind. In support of his argument, Mr. Glenn referred to the dictionary definition of welfare, which is capable of including general financial well-being. Construction of a phrase in the statute does not simply involve transposing a dictionary definition of each word. The phrase has to be construed according to its context and the underlying purpose of the provision. The words security and welfare have to be read together. I doubt whether Parliament intended welfare to be given the broad meaning advanced by Mr. Glenn, and I do not consider it to be fair, just, and reasonable to hold that the defendant owed a duty of care of that scope. So, my lords, if I may go on to consider what is the context and the purpose behind this rule, which has been in almost identical terms since 1982, albeit not in force until 1987. And generally, and I adopt here Lord Justice Arnold at paragraph 71 and Lord Sumption, generally, the purpose of a jurisdictional gateway is to insist on there being an identifiable and substantial link or connection between England and the claim made against the foreign defendant, which justifies or is capable of justifying the exercise of personal jurisdiction by the English courts over that foreign defendant. And we, if I could take you to pages 68, EF 68 and 69, sorry, yes, 68, 69, at paragraph 38 of our case. English law has never asserted jurisdiction on the basis of claimant's connection, whether presence, residence, domicile, or nationality. The purpose of the grounds is to provide a statutory basis for jurisdiction in cases where there's a sufficiently strong connection between England and the defendant. It's this essential connection which underpins the grounds. And there are then three quotations. Firstly, from Lord Porter in Tyne Improvement, the Brabo. Primarily, the jurisdiction of the courts is territorial in the sense that the contract or tort sued upon must have some connection with this country, or the defendant must be served here. My lords, if your lordships want references to these cases, that's at E4697. The second quote is from Metal and Rostoff, which we will return to, says the grounds upon which the court is permitted to assume jurisdiction are various, but all the grounds in differing ways require links between the foreign defendant and the English forum. And the third quote is from Conductive Inkjet Technologies. The gateways are various, but underlying all is the concept of a sufficient or appropriate nexus of the foreign defendant to the English forum. And finally, Lord Sumption himself, at the top of page 69, in different ways, all the jurisdictional gateways in the practice direction are concerned to identify some substantial and not merely casual or adventitious link between the cause of action and England. So specifically, the purpose of the wording introduced in 1982, which was in force from introduced I think in 1983, in force from 1987, was to align the Order 11 gateways for service out against non-EU defendants with the gateways provided by the Brussels Convention, and in particular in relation to tort, Article 5.3 of the Brussels Convention, which later became Article 5.3 of the Brussels Regulation, and then Article 7.2 of the Brussels Recast. The statutory instrument in question, my lord, is at 2916. I don't think we need to go to it, but the point I make is that the instrument changing the wording was made in 1983, and it was to be brought into force on the date when Section 2 of the Civil Jurisdiction and Judgments Act 1982 came into force, thus demonstrating beyond a shadow of doubt in my submission that the purpose was to align the new rule for non-EU defendants with the rule in the Brussels Convention. That is, in my respectful submission, quite clear.
Ms. Palmer, there's a question for you from Lord Lloyd-Jones.
I'm sorry, I wasn't looking up. It's very difficult.
Forgive me. If that was the purpose, why wasn't the same wording used?
Well, my lord, it was the purpose. I'm not saying it was to mirror in precisely the same way Article 5.3. I'm just saying that it is a jurisdiction. It was an expansion of the rule which existed before, which didn't allow any jurisdiction to be claimed on the basis of damage occurring in this country. So my lord will recall the case of Bière, where a polluting incident took place, I think, in France, and flowed through the River Rhine till it arrived in the Netherlands, where it caused damage. And it was apparent from the decision in that case that the damage occurring in the Netherlands was sufficient to engage Article 5.3 of the Brussels Convention. The amendment to Rule 11.1f was an amendment in the sense that it already said that jurisdiction could be claimed if the tort occurred within the jurisdiction. And this was an expansion in which it said that that it wasn't necessary for the acts comprising the tort to occur in the jurisdiction, so long as damage was suffered in the jurisdiction as a result of a tort committed elsewhere.
Thank you.
But the requirement or the purpose of alignment, in my respectful submission, is clear, that it would have looked most anomalous for a English litigant to be able to sue in this country in respect of a beer and potash type tort, which caused damage in this country, but not to be able to do likewise against a defendant who was in a non-EU country.
Thank you.
Mr. Palmer, there's a question for you from Lord Leggett.
Yes, Lord Leggett.
Mr. Palmer, haven't you just made the correct point about this, which is it would be anomalous if the English jurisdiction rules were narrower than the convention, but the converse would not be the case?
Yes, I would agree with that. I mean, that is a point in my favor, I'm glad to say, because
well, by the converse would not be the case, I mean that there is nothing wrong. In many instances, it is so that the English rules are wider than the European ones. And that might be so with this rule.
yes, I accept that there are some elements of the old Order 11 Rule 1.1 which were not reflected in the Brussels Convention and created a jurisdiction. But the enactment of this widening was itself already a pretty big departure from what Order 11 Rule 1.1F had said before this amendment, which, as I've said, as I've shown from the quotes from Munro and from distillers, were pretty restrictive. And so it was quite a wide enlargement to align it with the European rules. So, my Lord, what we had then was some guidance from the European theatre as to how Article 5.3 of the Convention was to work. And the case, which I won't take you to, is Bière and Mine de Potasse, which was a case of physical damage, as I've said, flowing down across a border and causing physical damage in a neighbouring country. It is, for your note, if necessary, at EF 3116. But perhaps I could take you to the case of Ruffer, which was the subject of a Advocate General's opinion. I think it was Advocate General Warner and not Slynn, who's sometimes described as the Advocate General, but it is at 3194. And at 3197, this does say it's the Advocate General Warner. Later, I think Lord Justice Mustle ascribes it to Sir Gordon Slynn. If we go to 3197, at the bottom of the left-hand column, the facts I should perhaps just describe are that a vessel sank in waters which were by treaty deemed to be German waters in the particular location on the borders. Because it was a German vessel, it therefore counted as having sunk in German territory. But the Dutch authorities had to clear the waterway, and they did so by removing the vessel, no doubt, and then trying to sell it off to pay for their removal costs. And one sees the way that the state of Holland was attempting to claim that the Dutch courts had jurisdiction over this. At the bottom of 3197, the state contended that the place where the harmful event occurred, within the meaning of Article 5.3, was not the place where the Ostratis sank, but the place where the state suffered damage consisting in the cost of removing the wreck insofar as that could not be recovered from the proceeds of sale of the wreck and of its cargo, and that the place was either The Hague, where the state had its seat of government, or Delfzijl, where it transpired that the proceeds of sale would be insufficient to cover the cost of removing the wreck. So if we then go to 3207, at the top, can the place where the harmful event occurred be the place where the damage is alleged by the state occurred, namely The Hague, where it's its seat of government, or Delfzijl in the arrondissement of Groningen, where the goods salvaged were sold by the state, revealing to what extent the costs incurred in removing the wreck were not covered. Just pausing there, obviously the place where the costs were actually incurred was still within the putative German territory, so it was no use to them. The question manifestly reflects the fourth contention put forward by the state. That contention is, in my opinion, ill-founded. The state relied in support of it on the decision in Bière and Mines de Potasse, but that authority does not, in my opinion, justify the contention. It was there held that the expression "the place where the harmful event occurred" was apt to cover both the place where the damage occurred and the place of the event giving rise to it. But the relevant damage in that case was the harm to the plaintiff company's seed beds in the Netherlands caused by the pollution of the Rhine. The place of the event giving rise to it was Alsace, where the defendant discharged saline waste into the Rhine. It was never suggested there, much less held by the court, that the place where the harmful event occurred could be the place where the plaintiff company had its seat, or the place where the amount of the damage to its business was quantified. As was pointed out to us in argument, both on behalf of Mr. Ruffer and the Commission, to hold here that the place where the state has its seat could be regarded as being the place where the harmful event occurred would be tantamount to holding that under the convention, a plaintiff in tort had the option of suing in the courts of his own domicile, which would be quite inconsistent with the scheme of Article 2 of the convention. As for the suggestion that the harmful event in this case might be regarded as having occurred in Delfzijl, think it enough to point out that the sale of the wreck was not a harmful event, but a means of mitigating pro tanto the damage that the state had suffered. And just again, drawing the analogy with what I've said before, that the domicile of a claimant in this country is no ground of itself for claiming the courts have jurisdiction over a foreign individual. So, my Lord, there have been a series of Court of Appeal cases that followed Ruffer, and in particular, three which have been referred to many times: the case of Metal and Rostoff, the Eras Isle actions, and the case of ABC against BFT, which we will look at later. But those Court of Appeal cases, we submit, came to very much the same conclusion regarding the distinction between direct and indirect damage as had been applied in Bière and Mines de Potasse and in the Ruffer opinion. Certainly that damage had to be direct and immediate, and that the financial sequelae of damage to property were not sufficient to engage the rule. The English authorities obviously came after 1987, and the first one very shortly after that, and they developed the same, in my submission, the same distinction. So if we could go now to Metal and Rostoff, which is at 2162. Which was a rather complicated case, and it's quite important in my respectful submission to get the facts right. The head note is at 2162. The plaintiffs were a Swiss company who traded on the metal exchange through brokers, AML. The plaintiff's chief aluminium trader instructed AML to open a number of accounts, and with the assistance of a number of employees of AML, he fraudulently traded, so that by February 1983, those accounts were all holding significant forward short positions with a total exposure of 6.5 million. Although AML, its American parent company ACLI, and the American holding company knew that G was trading fraudulently without their knowledge, without the plaintiff's knowledge, AML, to protect its position, asserted that the accounts were the responsibility of the plaintiffs, closed out the plaintiff's accounts on the exchange, and seized a number of the plaintiff's warrants. And that is important, that they seized these warrants. The plaintiffs began an action against AML and obtained an injunction, but the injunction was lifted as a result of a dishonest affidavit. The plaintiffs subsequently obtained a judgment for over 50 million, but recovered only 6.7 and no costs. As AML was insolvent, the plaintiffs then started proceedings against ACLI and DLJ and obtained an order to serve the writ out of the jurisdiction. The plaintiffs were claiming damages for conspiracy without alleging that the purpose of the conspiracy was to harm the plaintiffs. They also claimed damages under the heads of inducing breach of contract. The judge, under the letter B, the judge held that the plaintiff's points of claim sufficiently pleaded a conspiracy by AML and the defendants to convert or deprive the plaintiffs of their warrants. The plaintiff's claim for damages for the tort of abuse of the process of the court was misconceived. That was the affidavit point. And then on appeal, under 2, that under Order 11 Rule 1F, the court would only assume jurisdiction where the claim was founded on a tort and either the damage was sustained within the jurisdiction or the damage resulted from an act committed within the jurisdiction. And where damage had occurred in more than one jurisdiction, then the court would assume jurisdiction if significant damage had occurred within the jurisdiction. At holding 6 on 2164, that since the only cause of action available to the plaintiffs was that founded on inducement or procurement of breaches of contract and conspiracy not being available to, the judge proceeded on a partially incorrect premise in exercising his discretion to grant them leave. But that since the country was the place where the substance of the alleged tort of inducing the breach of contract was committed, London should be regarded as the appropriate forum for the determination of that issue. And then at 2169, at the very bottom, we have Mr. Justice Gatehouse's decision. Below letter H, the main breaches were these. AML had entered into 4 financing transactions with the plaintiffs, under which they lent their principal, some 31.8 million, against the security of metal warrants, the loan to be repaid with interest against the redelivery of the warrants. AML refused to carry the second stage through and seized the warrants, representing about 32,500 metric tons, for their own use. And at little 4, AML seized certain other warrants belonging to the plaintiffs, which they held in London in safekeeping. This was known as in-the-box metal, amounting to about 7,250 metric tons, and also warrants in respect of what was known as the Lamich ref metal, about 6,000 metric tons, held in Belgium. So there was this seizure of warrants, property, I would submit, which took place both in Belgium and in England. And if we go on then to 2181, which again is still Mr. Justice Gatehouse, at letter E, below letter E. AML's obligation was to return the warrants relating to the financing transactions in London to the plaintiff's subsidiary, Leopold Lazarus Limited. When AML refused to comply with this, the plaintiff's immediate damage was suffered in London, though its effects would ultimately be reflected in Switzerland. The ledger balance of 8.25 million was due to be paid in London, and payment was refused there. The plaintiffs were entitled to redelivery of the warrants in respect of the in-the-box metal in London. The immediate damage was in each case suffered in London. The immediate damage, I note. But the Lamich ref metal warrants were held in Belgium. Refusal to hold them to the plaintiff's order resulted in damage being suffered there. And then 2204 this is in the Court of Appeal, and it's, I can't remember which judge it is, I apologise. Between B and C, on behalf of ACLI, it was submitted that the damage suffered had been really in their pocket, and that damage had been sustained wholly at their headquarters in Switzerland. In the alternative, ACLI contended that the Lamich ref metal warrants were held in Belgium, and the refusal to hold them to M&R's order resulted in damage suffered there. The judge rejected that principal argument in this context, but accepted their alternative argument. And then at 2207, it is Lord Justice Slade, I apologise to you for not knowing it. Letter G, he turns to the construction of the new Order 11, Rule 11F. The grounds upon which the court is permitted to assume jurisdiction are various, and he sets them out. All the grounds in differing ways require links between the foreign defendant and the English forum. In this case, we're concerned only with 11F, which permits service out of the jurisdiction if the claim is founded on a tort and the damage was sustained or resulted from an act committed within the jurisdiction. Until 1987, leave could be given only if the action begun was founded on a tort committed within the jurisdiction, and most of the decided cases turn on that wording. The rule was changed to give effect to the Brussels Convention on Jurisdiction and the decision of the European courts in Bière and Mine de Potasse. As the rule now stands, it is plain that jurisdiction may be assumed only where the claim is founded on the tort, and either the damage was sustained within the jurisdiction or the damage resulted from an act committed within the jurisdiction. Condition B raises the question, what damage is referred to? It was argued for ACLI that since the draftsman had used the definite article and not simply referred to damage, it's necessary that all the damage should have been sustained within the jurisdiction. No authority was cited to support the suggestion, but this is the correct construction to which the rule gives effect. Of the convention to which the rule gives effect, and it could lead to an absurd result if there were no one place in which all the plaintiff's damage had been suffered. The judge rejected this argument, and so do we. It's enough if some significant damage has been sustained in England. And so I just point out there that the damage which was sustained outside England was in Belgium when the warrants were seized in that country. If we go on to 2219, at letter F, it seems clear, and M&R plead, that AML's first breaches of contract occurred in New York. Asoma, on behalf of M&R, were there told that AML would not pay the ledger credit. These were plain repudiations. There then followed further breaches when AML in London took the action threatened in New York. These breaches took place in London, and the judge was, in our view, right to treat them as the most significant breaches. Until these occurred, M&R had suffered little injury, and until then, AML could have availed itself of the locus penitentiae, which M&R's refusal to accept the earlier repudiation had given. It was the action taken in London in breach of the trading contracts, not the action taken in New York, which really injured M&R. And at over the page, the damage, at the top, the damage which M&R suffered as a result of the trading contracts was, in our view, suffered in London. They didn't receive the ledger credit payment, which should have been made in London, did not receive the warrants which should have been delivered in London and suffered the detrimental closing out of their accounts in London. Similarly, it appears that the damage caused to M&R by the compromise agreement was suffered in London, since security which should have been available was, it said, wrongly charged in London and paid out of London. And then just above letter E, M&R are also able under this head to satisfy the requirements of Order 11, Rule 11F. The claim is founded in what is, in English law, a tort. Significant damage has been suffered within the jurisdiction. That is enough. It's not incumbent on M&R to show that the damage was caused by tortious acts committed by the defendant within the jurisdiction. If it were necessary, we do not think that M&R could do so. So, although it's a little puzzling, they seem to conclude that the case comes under Rule 11F solely on the basis that significant damage was suffered within the jurisdiction. But that's all I want to take from Metal and Rostov. It was the sort of other way round in that case, that it was the defendants arguing that the damage had actually occurred where the head office was in Switzerland, and that was rejected for the direct and immediate damage which was caused in the way described in the Court of Appeal there. So I respectfully submit that both the respondents in their case and certain of the judges in the, I can't remember which corner it was, the green corner, are mistaken to equate Metal and Rostov with a decision which was that indirect damage had occurred, which could be mirrored, as it were, in other tortious cases. Excuse me. So if I could just take that point up by looking at Lord Wilson at EF 1798. At paragraph 62, Lord Wilson says, in the Metal case, the 1968 convention didn't apply to the issue of the court's jurisdiction. The defendants were domiciled in New York. Argued that were any action to be brought against them, it should be brought there. But the Court of Appeal held that the English court had jurisdiction to determine one group of the various tort claims made against them. The court considered whether the alleged torts within the group resulted from acts committed in England or alternatively in New York. It was enough, so the court held at 449D, that as a matter of substance, the acts were committed here. But the court also considered whether the damage was sustained in England or alternatively in Switzerland or Belgium, and gave the observations which we've just looked at. And he goes on, Lord Wilson goes on, the court proceeded to hold that significant damage, by which in the light of the above it meant a significant part of the damage, had indeed been sustained in England, and therefore the alternative ground for service also existed. And the definite article was removed from the words that the damage was sustained in order to reflect the decision in the Metal case. 63, the passage of the court's judgment in the Metal case set out above leads and entitles Lord's assumption at paragraph 30 to cite the case as exemplifying construction of Rule 11F and its successors in the light of the case law. But it is, I suggest, of greater significance that, as Lord Sumption explains in paragraph 29, by reference to the judgment of the Grand Chamber in the Marinari case, the Court of Justice has rejected any suggestion that the requisite harmful event has occurred in a member state in circumstances in which only a significant part of the damage has been sustained there. Well, my Lord, I'll come back to that, but that is incorrect in my respectful submission. The decision in the Marinari case was that indirect and consequential loss didn't count at all in deciding where the harmful event occurred. It wasn't a case of some damage being caused in Marinari and therefore it not qualifying. He goes on, if unlike in the beer case, damage is sustained in the state in which the causal act took place, the recast regulation does not confer jurisdiction upon the courts of the second state, even if significant further damage is sustained there. See paras 14 to 15 of that judgment. Well, it's difficult to understand how in a beer type case you could in fact have two sets of direct damage caused to the same property, because it's going to be downstream. But it doesn't amount to authority for that proposition. And then he says, where by contrast the jurisdiction of the English court is not governed by EU law, the decision in the Metal case demonstrates that our rules create a gateway wider, as is now clear, than EU law would permit. And that, in my respectful submission, is incorrect, in that it is possible, as was shown in Metal and Rostoff, for physical damage or direct damage to be caused in two separate places, in which case not all the damage caused by the tort occurs in the same place. But as long as it is direct damage of that sort, then it qualifies for the jurisdiction rule. But it does not in any way support the proposition that the English authorities have diverged at all from the decisions under Article 5.3 of the Convention. The case in Marinari was one in which direct damage occurred in England when promissory notes were impounded by, I think, the authorities or by Lloyd's Bank in England. And Mr. Marinari sought to sue in Italy because he said, well, the damage was really suffered in Italy when the consequential financial embarrassment was felt in my office in Italy. And the court, the European court, said that the financial losses in Italy were indirect losses which could not be brought within Article 5.3. And a very good example with respect is first instance decision of Mr. Justice Ricks in the case of Bastoni, which is at EF 3641. Here, in the second paragraph of the head note, the plaintiff was an English exporter of chemical products which sold 4 consignments to a Nigerian company. Payment for the 4 consignments was not made. Due to a fraudulent scheme, the plaintiffs were persuaded to send further consignments. A different English bank was instructed to collect the relevant bills. The plaintiff alleged that the representations contained in the telexes were untrue, obtained leave to issue and serve a writ out of the jurisdiction on the defendants. 3 years after it was issued, the plaintiff applied for leave to amend its writ and points of claim against the third defendants to introduce additional contractual claims and new claims for conversion or wrongful interference with the consignments of documents sent out to Nigeria. So that was the direct damage that was being sought. Over the page at 3642, the top line, the third defendant contended that no damage resulting from any tort had been sustained in the jurisdiction of England, and therefore the claim to serve out should be refused. If we go to 3649, towards the bottom, Schedule 11F, Subrule 11F, claims in conversion and wrongful interference. Mr. Justice Rick sets out the rule and says Mr. Schaff, for the claimant, accepts for these purposes that the relevant act took place in Nigeria. He submits, nevertheless, that damage was sustained within the jurisdiction. He relies upon the following matters. He points out that B&F reside in England and keep all their accounts there, that under the collection instructions, the proceeds of the bills of exchange should have been remitted there through New York to Barclays in London and applied there in reduction of B&F's overdraft facilities for which collection stood as collateral, and that but for EcoBank's mishandling of the documents, the former would have been returned to London, whereupon B&F would have been free to deal with them and the goods to realise their value in London. Mr. Gruder admits that the damage was sustained in Nigeria, where the goods were allegedly lost without bills being first accepted or paid for. He stresses that the failure to remit proceeds or to return the documents was only consequential on the prior alleged failure to maintain the goods in warehouse until proper acceptance or payment of bills. This, he submits, is not a case such as the manufacture of a dangerous drug in country A and its ingestion in country B, causing personal injury to in country B, where it can be said that the wrongful act is committed and the damage is sustained in different jurisdictions. If the mere fact that B&F are an English company and therefore ultimately feel the loss in their pockets in England is enough to render the damage sustained in England, then the purpose of Sub-Rule F would be subverted and every English plaintiff would be able to litigate in England virtually every case of tort, irrespective of where the tort was committed. Such reasoning would also subvert the similar provision to be found in Article 5.3, which the wording of what is now Rule F was designed to give effect to. And then 2 paragraphs further down, in the Eras Isle actions, Lord Justice Mustill pointed out Sub-Rule F operate easily enough where physical damage or personal injury are caused, but create problems in the case of economic torts. He rejected, however, the concept that a plaintiff suffers all its loss in the country of its head office by reason solely of its situs there, which would give the plaintiff in tort the option of suing the courts of his own domicile. And at 3651 over the page, under paragraph 15, in my judgment, after 15, in my judgment, in spite of the principle for which Mr. Schaff cited Metal and Rostock, which is not in dispute, these authorities support Mr. Gruder's submission that in this case, the damage was sustained in Nigeria. It was there that documents and goods were lost. It was only the financial consequences that were felt in England. If the documents and goods had not already been lost in Nigeria, it's true, the documents might have been returned to England and the goods disposed of. But by then, both had already been lost and the damage sustained. I therefore refuse B&F's application. And a clear support from the Court of Appeal in ABCI and BFT is given at EF 1499. Again, a case of fraud at the bottom of the left-hand column. ABCI alleged that by reason of the fraudulent misrepresentations contained in BFT's rapport annuel as to inter alia the nature and extent of the bad debt, ABCI was induced to enter into the contract with BFT to purchase shares and claim that the fraudulent misrepresentations were the result of conspiracy. And a little bit further down, STB applied to challenge the jurisdiction on the grounds that ABCI's claim did not fall within RSC Order 11, it should be Rule 11F, there being no relevant act or damage within the jurisdiction. And at 1513, towards the bottom of the left-hand column, Lord Justice Mance says Order 11, Rule 11F was formulated as it stood in 1995. Not sure where that date comes from. In order to be consistent with and give effect to Article 5.3 of the then Brussels Convention. The fact that the present case is not within the scope of the Brussels Convention is by the way. The significance of 11F was considered in the light of the authorities in the European Court of Justice by Mr. Justice Rich in Domicres. I'm afraid I haven't got that for your lordships. And then on the right-hand column, he deals under B, damage sustained within the jurisdiction. That brings us to the head of 11.1F, on which leave was sought and granted, namely damage sustained within the jurisdiction. The case is put in two ways. ABCI committed itself to investing here, and ABCI arranged payment here or from here. The pleaded commitment consisted, as we pointed out, in the making of a contract or in the making of the investment. The proposed amended case, which we're presently considering, that it was made by ratification, the meeting allegedly occurring in London. 43, Mr. Milligan submitted that an acceptance here or ratification here of a prior purported acceptance here would constitute in domestic law the date when a claimant suffered sufficient loss to acquire a cause of action in tort, citing D.W. Moore and Ferrier. But the Court of Appeal held in the fraud action that this domestic rule is not imported into the concept of damage sustained under Order 11 Rule 11F. Again, this reasoning is underpinned by the consideration that although the present is not a European case, Clause F was introduced in 1987 in order to ensure that English law was consistent with Article 5.3. Mr. Milligan submits that damage could be sustained in the sense of Clause F in two different places, and clearly that can be so in some cases, e.g. pollution from one source affecting different places, cf. the Bière case, but the proposition that the appellants could be regarded as having sustained damage within Clause F, both in the place where they purported to make or hold a board meeting ratifying the share subscription contract and the place where they made their investment allegedly under it, is less easy to digest. In our judgment, Clause F is looking to the direct damage, sounding in monetary terms, which the wrongful act produced upon the claimant. And citing Dumais, that was a case, my lords, where a company sued for the loss of value of subsidiaries which had been made to go bust. And it was held that the loss of share value in the subsidiaries was a consequential loss and not one that could be brought within the convention. Cited by Mr. Domicre, Mr. Justice Rick's own analysis in the outcome in Minster Investment. In the present case, that means the loss sustained by actually investing in an allegedly worthless company, not the entry into any prior contractual commitment, which might or might not have followed by the making of such an investment before discovery of the inaccuracy of the accounts. So the direct damage, as determined by Lord Justice Mance, would have been the investment of actual funds, which then were lost, and not the entering into a contract. But that is important in my respectful submission as Court of Appeal authority, that the concept of direct damage, being the damage referred to in the rule, is the only damage which can support a claim for jurisdiction over a foreign defendant. So if I can just summarize where we've got to. Before 1987, there was no gateway for serving out based solely on tortious damage. And it was said that if it was damage only before 1987, there was insufficient connection to justify bringing a defendant here. However, the Brussels Convention did provide for such a connection, as demonstrated by Article 5.3 and the decisions we've looked at. C, therefore, on joining the Convention, the non-EU permission to serve out was widened, but nothing in that meant that the need for a substantial connection was diminished. the Court of Appeal cases maintained the distinction between direct damage being sustained in the jurisdiction where sub-rule F was satisfied and cases where only the financial consequences were felt in England where it was not. And meanwhile,
one does have to be quite careful about this distinction. Your distinction you're drawing between direct and indirect is pretty critical. And the facts, as you've just described them, of the Dumais case, for example, where the direct loss is suffered by a subsidiary and the parent's consequential loss is regarded as indirect, are very different from the sort of circumstances we're concerned with in the present case, of course.
my lord, I have to accept that, and there isn't a previous Court of Appeal decision which has considered the crossover between these Court of Appeal decisions and cases in tort for damage to property, although obviously Bière was one such, and personal injury. But Lord Sumption, in his speech, does make it quite clear that there is only one way in which a direct damage can arise from a personal injury, and that is at the moment of injury. That is the direct damage, and the characterization of the consequences of that injury, namely continuing suffering over years in the future, and continuing financial losses, are not and cannot be, for other reasons, part of the direct damage which is contemplated. Certainly in the case of Henderson and Jaurun, which I hope to come to in a moment, the Court of Appeal in this country did consider Article 5.3 in the context of a personal injury claim, and said that a personal injury claim which had occurred in France could not give rise to an action in England based on the continuing deterioration of the symptoms of the injury in this country.
Now, I think, Mr. Palmer, that my colleagues are queuing up to put questions to you. I think first in the queue may be Lord Leggett.
Yes, my lord.
You've just been sort of spelling out Lord Sumption's conceptual reasoning about the distinction between the injury and its consequences, but you started by saying that we shouldn't be too hung up on one particular meaning. We should be looking at the purpose of the provision, and your underlying argument, I take to be that there has to be a sufficiently substantial connection. That's what it's all about, not something advantageous.
Yes.
Why isn't it sufficiently substantial if somebody who lives in England goes on a holiday, is briefly in another place, is seriously injured, and returns suffering from pain and disabilities as a result of the accident? Why isn't that a strong connection with this country between the
well, the only connection that exists with this country is the fact that the proposed claimant happens to be resident in this country. That isn't a connection between the tort which occurs in Egypt, the tortfeasor who is in Egypt, and this particular country, because there is no previous connection between that individual and the claimant. So if I have a car accident in Spain, there is no connection between me and between the person who crashes into me and this country, simply because I live here.
No, but the test is whether whether there's damage here, and it's entirely predictable that if you seriously injure somebody who is just on a brief visit from England, the damage will be suffered in England, isn't it?
Well, it may be foreseeable if you know they're from England, but the purpose of the connection is to establish a connection between the defendant and the English jurisdiction. And to say that that arises because where the individual whom you've injured returns to or goes to, because the claim cannot be different if you happen to injure a Greek person who comes back and is resident in this country. If you say that that is a sufficient connection, which it isn't, you're effectively saying that any resident in this country can sue for personal injury damages suffered anywhere in the world.
Is that you say that as if that's a conclusive argument against it?
Well, it is something which has never been contemplated before, that we should simply protect our own residents by pronouncing to the rest of the world that we will take jurisdiction over foreign defendants, haul them here and force them to defend themselves in our courts when they have no link, and the accident in question has no link with the courts of this country.
But is there not a constant line of first instance decisions which has done precisely that?
It has, and it's wrong to do so, man.
And the sky's not fallen in.
Well, the sky hasn't fallen in because, well, we don't know whether the sky's fallen in. I mean, people may find it extremely difficult to have to face these claims over here. And I'm not sure what response they can produce to make the sky fall in. All they can do is take the choice of not participating after they've been ordered to do so, in which case they're not allowed to defend the claim, or being forced to come into this country to defend the claim, and to lose such rights and privileges they might have in their own country. So it's extremely egocentric of the UK or England to suggest that they have the right to try any case involving one of their own residents.
Well, it'd be following the same approach as we're told is followed by courts in a number of other common law jurisdictions.
Well, it was followed. It's a course of action which has been taken in Australia in the Gergis case, but it does make a difference, in my respectful submission, that if you have a federal system like the Australian system, that you have a different balancing act to consider, which is whether it's really difficult for a resident in Queensland to be hauled into the courts of New South Wales in order to answer a claim in a road traffic accident there, compared to those being asked to come into a completely new environment and legal system from that in which they normally operate.
As you know, it isn't only Australia, there's also Hong Kong and Canada, I think.
Yes. Well, my lord, the Hong Kong decision, the Singapore decision, I think is just a first instance decision. Perhaps I could come back to that in reply.
Yes, there's a recent, I think we have two Hong Kong cases in the bundle, and one a recent first instance one adopting the Lady Hale approach. The earlier is a Court of Appeal decision prior to Brownlie 1. I'm taking up too much time. I think Lord Burrows also wanted to put something to you.
Yes.
Yeah, a couple of questions, if I may. The first is, I just wondered how far your approach has to deal with the fact that the English approach to these matters has to also decide whether or not this is the convenient forum, and that's already been decided that England is the appropriate forum in this case, as I understand it. My second question is the distinction that you're drawing between direct and indirect. I just wonder how easy it is to apply in certain circumstances, in particular on the facts of this case, isn't there a clear difference between the wrongful death claim, where the claimant is entirely suffering pure economic loss, that I would suggest is entirely suffered in this jurisdiction? So how does direct and indirect apply where the pure economic loss that is the basis of the claim is entirely suffered in this jurisdiction?
Well, that was a point which was taken by the Court of Appeal Part 1 in Brownlie, where they considered that the damage might have occurred in England in a fatal claim. But the European Court then ruled that under Rome II, which governs the law applicable to the claim, the damage all occurs in the place of the injury and death. So one would be, if one followed that reasoning, one would be acting at 180 degrees away from the decision in Lazar of the CJEU, that the damage occurs in a fatal claim at the moment and point and place of death.
But with respect, unless I've misunderstood, isn't that to do with governing law or applicable law? That's not to do with jurisdiction. And there can't be any precise read across from one to the other, because you can only have surely one applicable law, but that doesn't necessarily follow for jurisdiction.
Well, I accept that there is that distinction, but when one is considering what is damage, it is both if one starts from the purpose of this statutory provision, and if you start from the wording as or the meaning of the wording as ascribed by courts such as the CJEU and Lazar, you come to the same conclusion, namely that the relevant damage is that which occurs at the moment of death.
Yeah, Lord Lloyd-Jones, you're muted.
That may be inconsistent, Mr. Palmer, with the approach that you've urged us to adopt of interpreting the meaning of the words in the particular context. There can only be one governing law, but there could be more than one jurisdiction.
I accept there could be more than one jurisdiction, my lord, yes. But I'm just saying that the word damage in the context of this particular rule, 991A, is, well, sorry, 19A, arises from the purpose of the original legislation, and that gives damage the meaning direct damage, which is the death. And if one looks at damage in other senses, damage has also been interpreted for the purposes of Rome II as the place of damage being the place of death, not the place where the economic loss may be suffered. So, my lord, if I could go on to the errors that arose in the first instance.
Sorry, Mr. Palmer, I'm sorry, you may have forgotten my first question because I went on to a second, but did you have any response to the question about forum non-convenience?
Yes, I was just going to come to that, my lord.
Oh, I'm sorry.
If I may, because it was dealt with slightly separately by Lord Sumption in particular. But certainly one of the points of reasoning of the courts at first instance who've decided a slew of cases in favour of claimants on jurisdiction, they if I just take it in order, they failed to concentrate on the purpose and context of the statutory authority, not looking for a clear connection between the defendant and the claimant. they wrongly considered that Articles 5.3 and 7.2 had nothing to do with the proper interpretation of the widened ground that came in contemporaneously with the convention, and they also gave the words damage sustained a wide interpretation because they said, well, we can control who we force to come here and who we don't by operating the forum non conveniens doctrine. Perhaps I should deal with that now. I have the following reasons, which are supported by Lord Sumption and Lord Humes, as to why that is the wrong approach. That attempt at justification is contrary to principle, because the principle of establishing a gateway is to demonstrate a connection between the foreign defendant sufficient and this jurisdiction, sufficient to force that foreign defendant out of his own jurisdiction and into the English jurisdiction. Whereas the principle of forum non conveniens is to apply a further break if it appears that the actual trial, the practicality and location of the trial is more appropriate in another jurisdiction. That is to do with practicality, to do with evidence, ability to obtain justice, and so on. And it has nothing to do with ensuring a connection between the defendant party and the state asserting jurisdiction. And the rules have been consistent for as long as there's been a rule that there is a two-stage restriction on this ability to bring defendants here, which requires both those different considerations to be taken into account. There is also the question of certainty and discretion and difficulty, that a gateway requirement is a rule of law which has to be interpreted. It's your lordship's job to interpret the meaning of the gateway. Does it allow any form of consequential suffering or damage or loss to be accepted as triggering this gateway? Is a question of law and interpretation of the statute. The question of forum non conveniens, which is why it isn't, no doubt, why it isn't before you, is that it is a discretionary decision left to judges to determine on the evidence in individual cases. So the result would be that if you tried to merge the two or ignore the gateway requirement, say that anybody can achieve the gateway requirement, but we will try and limit the number of cases by reference to forum non conveniens. Firstly, you may not have the tools to do so because there's no connection test in the forum non conveniens context. And secondly, there won't be the certainty for litigants to know whether the case will be heard in this country or won't be heard in this country, because the decision in each case will depend on specific facts rather than, and on the exercise of the discretion of specific judges who don't all think in the same way, but the appellate courts don't interfere with them unnecessarily if they come to a discretionary decision which is within the sort of four walls of the discretion available to them. So it's contrary to principle. It has nothing to do with the connection test, and the solution is, in our respectful submission, jingoistic or harks from an imperialistic age when it was thought that only the English courts could adjudicate reliably on cases, which is A, not true, B, is antagonistic to other states, and it is, I don't think, generally thought of as being advisable or admirable to have a system in which you protect your own residents against personal injury or in-person injury actions to the exclusion of anybody else. Perhaps I could just look at what Lord Sumption said about this, because he said it quite shortly at paragraph 31 on page 1789. Having put forward why the rule, the gateway, was not wide enough, he said at paragraph 31 that Mr. Justice Tugendhat and Mr. Justice Haddon Cave rejected the policy considerations which I've described because they considered that the risk the gateway would be too wide could be managed through the court's overriding discretion as to forum non-conveniens. The scheme of the Brussels Convention is different, it said, because it is of its mandatory character. That view of the matter derives energetic support from Professor Adrian Briggs in his book and in various articles. Indeed, Professor Briggs has gone further, proposing that in the light of my own comments in Abela, the time has come to downgrade and eventually abolish the jurisdictional gateways and make forum conveniens and presumably reasonable prospect of success the sole criteria for service out. In my opinion, this approach is contrary to principle, is not warranted that anything was said in Abela. The jurisdictional gateways serve completely different purposes. The gateways identify relevant connections with England, define the maximum extent of jurisdiction. The ambit is a question of law. The discretion as to forum conveniens authorises the court to decline a jurisdiction which it possesses as a matter of law, because the dispute, although sufficiently connected with England to permit the exercise, could be more appropriately resolved elsewhere. The main determining factor of the exercise of the discretion is not the relationship between the cause of action and England, but the practicalities of litigation. The purpose of the discretion is to limit the exercise of the court's discretion. And he goes to Abela and Badarani. I protested against the importation of an artificial presumption against service out as being inherently exorbitant into what ought to be a neutral question of construction or discretion. I had not proposed to substitute an alternative and equally objectionable presumption in favour of the widest possible interpretation of the gateways, simply because jurisdiction thus conferred by law could be declined as a matter of discretion. So, my Lord, that is why in our submission, the solution is not an available one.
Can I, sorry, interrupt?
Yes.
And is Lord Sumption actually right to say that the discretion as to forum conveniens authorises the court to decline a jurisdiction which it possesses as a matter of law? It isn't the correct position that the court only has jurisdiction if the claimant A comes within a gateway and B satisfies the burden of proving or demonstrating that England is the most appropriate forum. So it's not as though the forum conveniens, as it were, is just a sort of comes in after jurisdiction's been established to take it away if you can show that somewhere else is more appropriate. Spiliada says you actually have to demonstrate that England is the most appropriate forum in order to establish jurisdiction in the first place.
Well, I think it's a matter of the word, the way one words it. But if one uses the word gateway, one does rather suggest that you start by looking at whether there is a sufficient connection to justify the next stages of the test. But I would have to accept that ultimately the question requires all three limbs to be answered in favour of the claimant, not just one of them. But what is being proposed by Lady Hale and others is that the gateway test is changed substantially so as to be incredibly wide, in fact, as I've said, wide enough for any resident to get through, and that everything should then be dealt with by the forum non-convenience test. And there isn't, in my respect for submission, the flexibility and ability to conduct the forum non-convenience test in accordance with proper principle, and at the same time to test whether there is sufficient connection between the cause of action and the foreigner who's being hauled over here to answer the case that's being presented. My Lord, I've just about run out of time. I'd just like to make one further point, which we make in our case, and I would like to make a number of other points, but I've had to miss out a bit of a chunk from here. But I would commend to you the Court of Appeal's reaction in the Erste Bank case at 2031 at pages 2072 to 2073, when they were informed of the line of first instance decisions in a personal injury context, and that those dicta were effectively accepted by the Court of Appeal in Brownlie 1, albeit with a wrinkle regarding fatal accidents, which caused a problem. Finally, then, if I could just bring in one further point, which is that the CPR, which has been relied upon to some extent for saying, well, ignore the statutory purpose and just look at the words because the CPR is meant to be easy to understand. That, in my respect for submission, is just wrong as a matter of law. You can't reinterpret what is a statutory provision because you've said you're going to try and make things simple without, if you're going to, getting the wording changed to mean what you want it to say. But in paragraph 34 of our case, at page 69 of the bundle, we would submit that having strong gateways is a way of advancing the interests of justice and to do so at proportionate cost and without delay, whereas putting everything into the hands of a forum non conveniens investigation is to do exactly the opposite. And finally, may I just commend to you, I think a document which may have come from your lordships originally, which is a Bloomsbury publication of a chapter on forum non conveniens by Ms. Louise Merritt, which we would submit puts the arguments either way extremely carefully and fairly, and we would submit supports the position that we take, that given the nature of personal injury, there is an injury inflicted once and for all, and to suggest that when the victim of the injury comes back, she or he continues to suffer damage as wages cease to be paid over a period of time, or care costs mount up, or symptoms flare up or continue, is quite wrong. And if one is tempted to dismantle this particular paragraph of the order, one must remember that it does govern all torts, not just personal injury cases or personal injury cases arising out of road traffic accidents. And if the wording is given a new meaning, we respectfully submit that it will cause serious disruption in other areas of tort, which where the courts have to consider the meaning of Rule 9(1)(a). My Lord, as I say, I think that is my guillotine, so I will stop. Thank you very much for listening to me.
Very much, Mr. Palmer. You're slightly, I think the guillotine would have dropped a few minutes earlier.
Yes.
If Ms. Crowther requires all the time she's indented for, then you'll come off your reply time. So, Ms. Crowther.
I'm grateful, my lord. Let's see how we get on. I'm aware that it's been a long day on the screens already. So I propose, if your lordships are content, to address the merits point first, and then we can have a look at Tort Gateway in the morning. It's possible we might need to deal with a bit more merits then as well, but let's see how we get on. My submissions on merits initially are going to fall under 4 headings. I'm going to talk about the legal standard for the merits test in a jurisdiction challenge first. Then I'm going to have a look at some of the evidence that was before Mr. Justice Nichol and the Court of Appeal. Thirdly, I want to take you to some of the findings which have been made by both the first instance judge and the Court of Appeal about that evidence. Fourthly, hopefully we'll have time for that this afternoon, the standard of review on appeals on the merits test. So it's worthwhile, I would submit, to remind ourselves briefly of what the correct test is on the merits part of a jurisdiction test. And we found that in Sequensar. I think that's common ground, but the reference for your lordship's note is EF 2518. Is there a serious issue to be tried? Mr. Justice Floor put it quite nicely in my respectful submission. He says, does the defendant have a killer point? And he says that at EF 1965, that's in our written case at paragraph 57, which is 131. And we can see also that the same kind of test has been set out in Vedanta, and the references there are 2135 to 2136. It's broadly replicating a summary judgment test. It's designed to weed out cases that are not fit for trial. It is not intended to be a minute and protracted examination of the documents and facts of the case. I would like to turn up, if we can, VTB Capital, because in my submission, I think there are 3 points that we can get from VTB Capital which are pertinent to this appeal. It's at 2716, if I may, which is tab 3 in PA3. Tab 36, sorry, in PA3. And if I may, it's in the judgment of Lord Neuberger, starting at 2716, which I now can't find, apologies. At paragraph 82, he says, the first point is that hearings concerning the issue of appropriate forum should not involve masses of documents, long witness statements, detailed analysis, and long argument. It is self-defeating if, in order to determine whether an action should proceed to trial in this jurisdiction, the parties prepare for and conduct a hearing which approaches the putative trial in itself in terms of effort, time and cost. There's also a real danger that if the hearing is wearing expensive and time consuming, it will be used by a richer party to wear down a poorer party, or by a party with a weak case to prevent or at least discourage a party with a strong case from enforcing its rights. We submit that there are strong echoes of what Lord Neuberger was saying going on here. There clearly is a rich defendant. They clearly have a weak case. And that's why we're stuck in this procedural vortex, frankly. The second point, my lords, arises out of paragraph 90, which is on page 2718. Lord Moonberger says it's a subset of the first point. It concerns the extent to which a defendant who is challenging the jurisdiction of the English court should identify the nature of his case. In my view, the position is reasonably clear. As a matter of principle, a defendant is entitled to keep his powder dry. He can simply put the claimant to proof of his case. And we'll see in a moment that that's essentially the course that the defendant has elected to take here. That's true at any point of the proceedings. The mere fact that the defendant is challenging jurisdiction does not so impose on him a duty to specify his case. The onus is on the claimant to satisfy the court there's a serious issue to be tried on the merits, and not on the defendant to satisfy that he has a real prospect of successfully defending, However, if the defendant chooses to say nothing, then it'd be quite appropriate for the court to proceed on the basis that there is no more and less to the proceedings and will be involved in the claimant making or trying to make out its case. Of course, in many instances, the defendant will be able to say that although he's not submitted a draft statement of case or produced a witness statement setting out the details, its nature is clear from correspondence, common sense, or submissions. Consistent with my observations on the first point, I would not encourage defendant to go into great detail as to his case in a long document with many exhibits, but if he's wholly reticent about it, he can have no complaint if the court does not take into account what points he may make or evidence he may call at trial. I agree with Lord Clark, and the reference there for your lordships, we won't need to go to that, is 2752, that a defendant could exhibit draft points of defence, but in many cases it'd be disproportionate to expect him to incur all the costs. And then the third point we get from paragraph 92, where he quotes Lord Bingham from the Lubber and Cape litigation. He says, in the context of stay for FNC, this is a field in which differing conclusions can be reached by different tribunals without being susceptible to legal challenge. The jurisdiction to stay is liable to be perverted if parties litigate the issue at different levels of the judicial hierarchy in the hope of persuading a higher court to strike a different balance in the factors. But then just above paragraph 93, and importantly in my submission, he says this, precisely the same applies in many cases involving permission to serve out. And that's in the context of the serious issue to be tried issue. So there's clear guidance there that this kind of repeated appeal on the question of serious issue to be tried is to be discouraged. So does the defendant have the killer point that Mr. Justice Flo referred to? Well, we say, in keeping with its behaviour in the first round of this litigation, it's chosen very much to keep its powder dry. And the starting point for that, if I may, in the evidence, is at the core volume, page 260, which is EF number 415, please. This is the witness statement of Mr. McManus, who's the solicitor acting on behalf of the defendants. And you'll note it's the same legal team who've been acting throughout this case, even before when as it turned out, what the wrong defendant was being sued. So it's the same legal representatives. And this is what was put in as the basis of effectively the challenge to the jurisdiction. Now, I acknowledge my learned friend's right. It hasn't operated in the perhaps traditional way where you have a Part 11 application because of slightly unusual circumstances of the case. But the paragraph that I'd like to take to of the witness statement is paragraph 47, which is at page 425. Mr. McManus says this, I believe the court will not grant jurisdiction to serve the proceedings out where the claim sought to be brought has no real prospect of success. For reasons including the application of the rules of limitation under Egyptian law set out in Mr. Ezo's report and referred to above, I believe the claims the claimant seeks to advance do not have any prospect of success. That is the only reference in the defendant's evidence that was before Mr. Justice Nicol to what its case was going to be about the reasonable prospect of success. Now, I completely accept that by the time my learned friend, Ms. Kinzer, was instructed, she put in a skeleton argument and she particularised it in more detail. But at that stage, there was absolutely nothing more in it than that. Now, we all know that all the limitation issues have now fallen away. But I think one has to be fair to Mr. Justice Nicol that when he was looking at this evidence, he was looking at it very much through the lens of what was then in contention, which was the limitation point, which the defendant had raised fairly and squarely on Egyptian law evidence. There were questions about the concept of Kamul, which have now also fallen away. But all this stuff about was there a cause of action and is there a contract and things like that was never addressed square on as being things that needed to be dealt with in the evidence. And we've set out in our written case what we think the position before your lordships now is. And if I perhaps take you to that, it's at paragraph 66 of our written case, which is at 134. So you can see at 66, we've referred to the case management order of Mr. Justice Stewart and the order of the reports. But at 69, we've set out there that the Egyptian law demonstrates the claimant has a real prospect of success on a claim in tort based on vicarious liability of the defendant for the driver. On the question of limitation and cumul, an entitlement to damages for her injuries and the estate, as well as being a dependent. And we also say that it sets out a direct claim in tort. And at paragraph 70, we've referred to the passage of Mr. Edge, that's the claimant's expert, where he deals with the question of vicarious liability. I think Ms. Kinsler suggested in her submissions that that was only in relation to the tort claim, but our submission is that paragraph 38 of Mr. Edge's report isn't limited in that fashion, and it relates to the question of vicarious liability regardless of whether the claim arises as a question of tort or contract. And then at 72, we make reference to paragraphs 59 and 56 of Mr. Edge's report. The claimant is entitled to damages for all her own physical and material injuries caused by the accident. This is at 135 in the bundle, where in our written case. The claimant is entitled to damages for all the losses she'll suffer as a dependent based on what she was likely to receive from the deceased over her lifetime. The claimant will also, as primary heir and executrix, be able to claim on behalf of the deceased for his wrongful death for the benefit of his heirs. And at paragraph 20 of the report, he deals with tortious obligations. And we've quoted the relevant passage for you there at 136. Suffice it to say that it's a very broad duty which is owed in Egyptian law. And Mr. Edge observes that it might even be said to be broader than the one in English law. And so for those reasons, we say that both Mr. Justice Nicol and also the Vice President Underhill were clearly right to say that this matter ought to go to trial. I would add to that, if I may, the fact that there have been various concessions made throughout the course of this litigation, which also add to that. In fact, it is now common ground that there was a contract between the parties. And it's also now common ground that the defendant was a principal to that contract. And it's also common ground that the driver was acting in the course of his employment when the accident occurred. So the only point that possibly technically arises is this question of whether, in organising an excursion for a foreign tourist who's a resident at their hotel, the hotel owed any duty to exercise reasonable skill and care in doing so. And we submit that insofar as Ms. Kinsler advances that proposition, she's absolutely on all fours with what was said in Parker and Toohey, the idea that a hotelier in those circumstances could do so without any regard to the safety at all of participants is a startling proposition. I think breathtaking was the word that was used there, but it's the same case that they're putting forward. So, my lords, that's where we get to on the case. Now, as Lord Neuberger said, is the defendant's entitled to keep their powder dry on the factual case if they want. But we do submit that it is also slightly unusual in this case that when it came to instruct its expert of Egyptian law, it expressly told its expert not to comment on the contract case. So if we go to page 502, at paragraph 24 of his first report, Mr. Ezo says this: I've been asked to address the potential causes of action available to the claimant in respect to the claim she seeks to bring against the proposed defendant on her own behalf and on behalf of her husband's estate. For reasons I will address further below, it is necessary to consider the claimant's potential contractual claims first. My report below is prepared on the assumption that there was a contract between the claimant and the proposed defendant. I'm instructed that I am not required to express a view on this issue. Now, my lords, that is a position that the defendant is entitled to take, and I don't criticise them for that. But what I do say is that it ill behoves them then to complain that the claimant has not adduced evidence demonstrating what Egyptian law is about whether a hotel owes a duty of reasonable skill and care to its customers in organising an excursion, when it has had the opportunity to do so and has expressly instructed its expert not to raise it. And it's not raised in the witness statements either. And against that background, we say that what Lord Neuberger says is absolutely pertinent, that the judge is entitled to assume that there's going to be an issue here. And that is clearly something that's fit to go to trial, bearing in mind particularly that we're in a situation where this is a jurisdiction challenge, and there is undoubtedly going to be further expert evidence on both sides, and witness evidence and documentary evidence before we get to trial. So against that background, we say it's wholly unsurprising that there was a concurrent conclusions reached at both first instance and the Court of Appeal, that there were serious issues that needed to be tried, and that there was no reason to dismiss the claim effectively on the summary judgment test at this time. And we can see that from Mr. Justice Arnold's judgment, where he deals with this issue. And I give you the references. It's at page 194 and 195 in the electronic bundle. And Lord Justice McComb agrees at 181. And Lord Justice Underhill also agrees at 206. So that's what I wanted to say about where we get to on the merits points in general. And my fourth point was going to be about the standard of review. I hope Lord Briggs can forgive me for this, because obviously this was Lord Briggs's judgment. So I'm conscious it's 10 to 4, so he might not want to hear his own words back at him at this stage. But it is from Vedanta. And we've dealt with this in our written case, which is probably the easiest way to go to it. And that's at page 138 at paragraph 79. Essentially, Lord Briggs, as you said there, we rely on the fact that you said that the rationale in such a case is simply that the court should not subject a foreign defendant to proceedings which are liable to be summarily dismissed. But moreover, appeals in this field, judicial restraint is of particular importance, and an intervention by the Supreme Court should be wholly unusual, especially where there are concurrent findings of the evaluative nature of the first instance judge. And the actual Vedanta reference there is 2136 at paragraph 12. And we've got it in our written case at page 141. In addition to that, this court should be very slow to interfere with the methodology of the first instance court in coming to its determination as to whether there's a serious issue to be tried. And that's paragraph 13 of the judgment. And the electronic reference is 2136 to 2137. And in our written case, you can see that at 142. We say that Lord Justice McComb, when he dealt with this issue, which is in our written case at 139, applied the correct appeal test. He said, you've got to take a step back, look at it in the round. And Lord Justice Underhill also emphasised that Mr. Justice Nichol was not obliged to make a definitive finding on any point. He needed only to decide whether the respondent had a real prospect of showing under Egyptian law she was entitled to claim in those capacities. And we submit, if you look at the matter in that way, you cannot criticise Mr. Justice Nichol. He's done exactly what he was supposed to do. Now, the way it's put to you this morning, there's heavy emphasis on the pleading point, saying that that somehow usurps all of this. We simply say that there's an air of unreality about that, that when you get to a point where the judge has got all this evidence in front of him, which sets out that there clearly is a serious issue to be tried, the question of going back and then saying, what do we have to plead about it, doesn't really take things any further. And under questioning, it seemed to us a little bit unclear exactly what it was that the defendant was complaining that we hadn't done. At one stage, it seemed that my learned friend was suggesting that what really needed to be done was that source materials of Egyptian law needed to be. So in other words, we pleaded material facts in our pleading, but we hadn't attached Egyptian law labels to those facts. But later on, in answer to further questions, she suggested that as long as the material content of Egyptian law had been pleaded, then that would be sufficient. And we note that there has never been a comprehensive, either kind of Part 18 style request or other list of particulars at any stage in these proceedings that has been said to be materially wrong with our pleading. I mean, if you look at it from a step back perspective, it's a very straightforward factual scenario. Yes, sorry, my lord. Oh, sorry, I can't hear you. Oh.
Pleading issue before the court. Is there a pleading issue on this appeal, or are we solely concerned with whether the merits test was satisfied for the purpose of service out of the jurisdiction?
Well, my lord, I'm not sure that I'm the right person to answer that question with respect, because that's not all that the court needs to satisfy itself is that this is a suitable case for service out, and part and parcel of that is the merits test. I was explaining it to my children, and they said, "Oh, it's like buy one get one free, mummy. You have a test on this, and you get a merits test thrown in." The extent to which that extends to pleadings in particular must always be a question of fact and degree in any particular case. I mean, all that I say here is that given the circumstances in the round, how can it conceivably be said that either Mr. Justice Nichol or the majority in the Court of Appeal were wrong to conclude that there's a serious issue to be tried? It might be that further down the line, further case management on pleadings might take place, and there was discussion in the Court of Appeal, which is presumably why ultimately we ended up with the order that we did for further pleadings about that. We put the cross appeal in as out of an abundance of caution, if you will. Our position is that there are material facts there that set out a claim. There's more than enough for the defendant to know the case it has to meet. If it thinks that either in some material respect there is an omission of fact that would be material to Egyptian law, then it's entirely able to plead that in a defence. If it thinks that there are extraneous matters that we've pleaded that are irrelevant to Egyptian law, I'm sure they'll be quick to point that out as well. In which case we'll know immediately what's actually material in the case to actually deal with. At the moment, it's a little bit like shadowboxing because we're dealing with it in the abstract as to the points that might be taken or might not. I think a little bit what Ms. Kinsley's doing is kind of standing to her rights a bit rather than actually getting down to working out whether there really is a dispute between us on that. I don't know if that answered my lord's question.
Well, not entirely. I mean, Lord Newberger in the passage who cited pointed out, I think, or one of the paragraphs that you don't have to have your particulars of claim when you're applying to serve a writ out of the jurisdiction. Isn't that a step further down the line that could be argued about, you know, if they're sufficient or not, but we're just concerned with whether it got over the hurdle of the service out?
Possibly, although I'll be frank, I mean, that's a distinction that I've never sought to draw in arguing this case, and I think people might pull a face if I took a point at this stage. I mean, I suppose being utterly pragmatic about it, the reality is that the particulars go hand in hand with the claim form. So you'd have a short summary of what the claim is, but once you've got your particulars, then I'm not sure that the court can kind of step back and say, well, I'll just look at the claim form and not at the particulars. I might be arguing slightly against myself at this point, but...
Well, just the last point I make is that, I mean, the court could be satisfied, couldn't it? There was a serious issue to be tried because it's reasonable to assume, or one could be tolerably sure that Egyptian law is going to have a basis for a claim in contract. But nevertheless, you might think, sorry, I'm getting a lot of feedback. I don't know if that's off your...
let me mute.
It might be that the statement of claim isn't sufficient in that it's failed to plead particulars of the provisions which could be requested and or could be asked to amend or something like that. But that doesn't mean that there isn't enough basis for you to get jurisdiction. Would that not be right?
My lord, maybe I misunderstood your previous question. I mean, certainly we would agree with the proposition that questions of what needs to go into pleading are essentially those of case management, which can be dealt further down the line, as long as the court is satisfied that the merits test is met.
Thank you.
Now it is 4 o'clock. that is essentially all the preliminary observations I wanted to make about the merits point. I was going to move on to a new topic about the presumption and the default rule, unless there are any further questions on that. And I'm looking at the clock, and it might be a convenient moment to stop anyway.
No, that's a convenient moment. Thank you very much. We'll let you go and discuss tomorrow's issues with your children. And we'll adjourn now until 10:30 tomorrow. Thank you very much.
I'm grateful.